Hello and welcome to the Yoga Lawyer Show. Today we're going to be talking about the recent Supreme Court decision of the travel ban, upholding the travel ban. A few weeks ago we talked about the oral arguments regarding the travel ban because we watched those and we gave some info. We can link the video to that one. But now the Supreme Court...
In the cards.
Yeah.
Is
Where is it?
in the corner somewhere.
Make sure you put it there, right?
Yeah.
And now they actually released the opinion, which they basically upheld the travel ban as constitutional. So we're going to talk about that. It was a very interesting case. As with a lot of these cases, it was split 5-4. We see conservative justices on one side and the more liberal justices on the other. Roberts wrote the majority opinion, and he basically said, or the basic gist of the majority opinion was that the president has broad authority to restrict certain foreign nationals from coming into the United States. That authority falls under the Immigration and Nationality Act, which I think we talked about that act when we talked about the zero tolerance policy.
Yeah, the immigration video that we just put out. So.
But basically it grants the president authority to, quote, suspend entry of all aliens or any class of aliens when he finds that the entry would be detrimental to the interests of the U.S. So that was the basis of the president's authority, and the court said the president has authority to deny entry, and they weren't going to step in this case and deny him that authority. The majority decision, here's another quote, leaves undisturbed a policy first advertised openly and actually that's from the dissent. I'll get into that. We'll get into that in a minute because the dissent's really good.
Yeah, it's so good. It's pretty long.
But basically the majority said the court cannot substitute its judgment regarding national security for the executive branch, which this was interesting. Roberts said that deciding the interests of national security involves, quote, large elements of prophecy. I don't know if you saw that, but I found that interesting. But yeah, the court's basically saying they can't step into the shoes of the president. It's not their place to judge. If the president decides there's a national security interest, then that's the executive branch's MO, and it's not for the courts to come and step in and substitute their judgment. Which, makes sense in a lot of ways. We always joke about when we read these opinions, we're like, oh, that makes sense. You read the majority.
We're like, oh, the majority makes sense.
Then you read the dissent, and you're like, that makes sense. Makes sense too.
I have a love-hate relationship with the Supreme Court.
But, just to kind of relay the history, this was the third version of the travel ban. It's very questionable whether the first or second versions would have been upheld. It was like the president got 3 bites of the apple, and he finally came back on the third version and, was able to write it in such a way that it would survive constitutional scrutiny, for lack of a better way to say it.
Yeah, which, speaking of constitutional scrutiny, they looked at the rational scrutiny,
rational basis test.
Yeah, which is like the easiest one for the government to pass. And that's not usually the scrutiny they use for establishment clause cases, which is what Sotomayor pointed out in her dissent. She was wondering why they used that.
A rational basis versus strict scrutiny or a more intermediate.
Yeah, and she said that it's plain that the proclamation wouldn't have passed even intermediate scrutiny.
Interesting. But yeah, so we could get into that. Well, let's talk about the concurring opinion. And just, again, the basic history of this is that it bans people from 8 different countries, 6 of which are predominantly Muslim, Iran, Libya, Somalia, Sudan, Syria, and Yemen.
The
from
third
entering the country.
variation tacked on North Korea and Venezuela.
Yes, go ahead.
They were kind of just like... It was kind of a gimme to make it look like it wasn't so much of an attack on Muslim majority countries, but we already have a lot of really strict rules with North Korea, and Venezuela only targeted certain government officials, so it didn't really do much.
In effect, it didn't do much with either of those countries. In effect, it was mostly about the 6 predominantly Muslim countries. So Kennedy joined in, and the majority opinion also kind of focused on the fact that there's exemptions and waivers. And this gets talked about in the dissenting opinions, but that basically, even though it's a complete ban, there's exemptions and there are waivers so that in theory, people from these countries could still enter the U.S. If they meet certain criteria.
In theory.
And we'll get into that in a minute. But so Kennedy wrote this really interesting concurring opinion. It's only like a page and a half long, and it's being cited a lot in the news media.
I'm going to get this tattooed on myself.
But he warned that even though he was supporting the majority opinion, and he said that the court will not step in to correct actions, but, quote, that does not mean that those officials, like the president, are free to disregard the Constitution and the rights it proclaims and protects. So it was kind of a stern warning, like, even though we're upholding this, you still have a duty to uphold the Constitution and the rights that it protects. So I don't know that that has much teeth to that, but it was obviously...
I don't think it has that much teeth to it, but it's a nice gesture.
And it's, some
I'm not sure how much
quotable material in there that
True.
we're hearing on the news. So
that's the benefit of these. If you're ever wondering why justices will write concurring opinions or dissenting opinions or concurring in part, it's for that precedent, so that a future court can use that.
Yeah, they can still cite to the dissenting opinion even though it wasn't the holding of the case.
And it still has some kind of muster.
So
if it's a dissent.
Going to the dissent, because this is where it gets more interesting. So the dissent kind of picked up on the exemption and waiver aspects, because that was a lot of the basis for the majority's opinion, that it's okay because there's these exemption and waiver provisions.
First, there are two dissents.
Yes.
Breyer wrote one, joined by Kagan, and then Sotomayor wrote a second, which was the primary dissent. It was like 20 pages long, and that was joined by Ruth Bader Ginsburg.
Gee. But so Breyer had said that basically in practice these exemption programs are not doing anything, and he quoted an affidavit from a U.S. consular official who said that they're, quote, window dressing, and that this consular official has no authority to grant waivers. So in practice, the waivers aren't happening. And you had some numbers we were talking about before the video.
Yeah.
What was it?
They had 6,555 eligible cases, and 2 of them were granted.
So they're not really granting waivers or exemptions. So
it's a nice thing
window
that they're
dressing
saying in theory, but in practice, they're not actually using the case-by-case basis exemption program that's put out in the proclamation.
So no one's really getting in on exemptions or waivers in practice, even though it's allowable in theory under the proclamation. And
he actually noted a specific case of a girl with cerebral palsy in Yemen, where she would have died if she stayed in Yemen because for some reason she was being denied her medication and she needed to come to America or she was going to die, and they denied her case. And then after the publicity, they sent out another kind of document that said that her case was pending. And Breyer thought that was interesting. Why didn't they say, if it was pending this entire time, why did they initially deny it? So I thought that was interesting.
Yeah.
That was just a part of his concurring opinion.
Which brings us to Sotomayor's dissent, which I think we both found the most interesting.
Yeah, I'm going to name my cat. My cat.
Sonia. And she basically said we can't ignore the president's anti-Muslim statement. So the majority basically said that, we're just looking at the 4 corners of this proclamation, and the preamble to it declares the purpose of it and, what the President Trump said as a candidate, and even what he said on Twitter and
as president
doesn't get considered. The fact that he's come out and said that this was basically an anti-Muslim ban doesn't get considered because on the 4 corners, the plain language of the document says otherwise, and that there's a legitimate, rational state interest or government interest in protecting national security.
They just had like a little blurb about that. They barely mentioned all of the stuff he was saying. And Sonia went into a couple pages of a detailed narrative leading up to like why she thinks that it's very clearly animus against Muslims.
Yeah, one of the quotes she said was that the majority decision leaves undisturbed a policy first advertised openly and unequivocally as a total and complete shutdown of Muslims entering the United States, because the policy now masquerades behind a facade of national security concerns. It does so, she lamented, by ignoring the facts, misconstruing our legal precedent, and turning a blind eye to the pain and suffering the proclamation inflicts upon countless families and individuals, many of whom are United States citizens.
So that's her talking to the majority opinion and telling them that she didn't think it was fair that they completely left out all of the history behind the proclamation and everything that led up to it and its specific wording. And
it was interesting because she cited the Masterpiece Cake Shop case, which we talked about also a couple weeks ago. And in that case, if you remember, the Supreme Court upheld, it didn't really address the merits of a baker's right to refuse a homosexual couple a cake, but it said the reason it was reversing the decision below was because the state court, it was actually an administrative agency type court, did not neutrally apply the law. In fact, it was very biased against this baker's religious right to free exercise of his religion. And so she was kind of taking that opinion and said, in that case, we reversed a state agency who did not act neutrally. But
they looked at what the agency was saying.
Yes, and the agency had said, and we even quoted it in the video, a lot of really kind of anti-religious sentiment, and it was like, whoa,
they weren't being fair,
and they said it, and
acknowledge that.
Yeah,
absolutely.
And she said that in this case, we're completely setting aside the president's charged statements about Muslims as irrelevant, but that wasn't done in the Masterpiece Cake Shop case, where obviously they found the state administrative court's statements important in finding that the baker was not given a neutral hearing.
Yeah, so that kind of brings in Kennedy's opinion. So why would the majority look at the statements in Masterpiece but ignore the statements of the president in this case? The president's not above the law, and that's what Kennedy was saying.
Yeah, but he's basically saying even though the president's not above the law, the president sort of has his own duty to make sure he's doing the right thing, and the courts aren't going to step in.
But what the majority opinion was kind of doing, I mean implicitly, not explicitly, but by ignoring his statements, they were kind of putting him above the law a little bit.
Yeah, saying he can make statements
that we're going to disregard, those don't
consider
matter.
That.
We're just looking at the plain language.
It's kind of scary.
It's a little unfair considering that the same majority, I don't know if it was the same majority, but the majority decided Masterpiece in such a way.
You don't know if it was the same 5.
Yeah, I don't know.
I'm not sure what Kennedy did in that one. It was 5-4 and no, Masterpiece was 7-2.
Oh yeah, you're right.
It was 7-2. Because that one,
so
the judges all decided.
The majority was in Masterpiece. Because it was just Ruth Bader and who else?
I don't remember who dissented besides Ginsburg. But the majority of the court, which was 7 justices in Masterpiece Cake Shop, all agreed that this baker didn't get a fair and neutral hearing below. And they considered the statements of the court as evidence that it wasn't neutral. And here, applying a similar analysis, the court ignored the statements of the president. The other interesting thing that Sotomayor talked about in her dissent was the Japanese internment camps case, Korematsu, which in the 40s the Supreme Court upheld, and it was again 5-4. There were 4 dissenting justices then, and that case has been the law of the land up until now. And in its majority opinion,
if you're unfamiliar with Korematsu, it was the case that upheld FDR's policy of Japanese American internment. So they would take Japanese Americans and kind of put them in concentration camps a little bit.
Yeah, a little bit.
A little bit. That's
they were in concentration camps.
That's what they did. A little bit.
Like American citizens were taken out of their homes and brought to concentration camps, and the Supreme Court upheld that as valid for national security reasons.
In a time of crisis, which is kind of interesting. I think that's what the majority was centering on, was that was like during a time of crisis, and of course the majority goes on to overrule it.
So yeah, the majority, Roberts came out and said that what they did in Korematsu was gravely wrong. And
I'm
yet,
glad he said that.
Yeah, so that was the first expression, like a direct expression by the Supreme Court overruling Korematsu. But they seem to kind of be following a similar precedent here, which is what Sotomayor says. She said, quote, "Today the court takes the important step of finally overruling Korematsu, denouncing it as gravely wrong the day it was decided. This formal repudiation of a shameful precedent is laudable and long overdue, but it does not make the majority's decision here acceptable or right. By blindly accepting the government's misguided invitation to sanction a discriminatory policy motivated by animosity toward a disfavored group, all in the name of a superficial claim of national security, the court redeploys the same dangerous logic underlying Korematsu and merely replaces one gravely wrong decision with another."
Yes, the majority said that Korematsu isn't really applicable here because the scenario that Korematsu was decided in is so different, but I don't know if that's fair, because it's not...
Well, and time will tell whether, years from now, like how long ago was Korematsu? It was like 1944 or something. Mm-hmm. So, 80, 90 years from now, is the Supreme Court going to come back? I guess 70, 80 years. Are they going to say, oh, we were gravely wrong in the Hawaii
I hope it doesn't take that
case?
When she mentions a superficial claim of national security, she's kind of right. Like, if you're going to defer to the president's authority in cases of national security, how far does that go? Because you could probably make a claim of national security interests in any situation. Like, for instance, you can make a healthcare claim of national security. Like, you need to fund some certain healthcare or have some provision about healthcare for national security in an effort.
Like if there's an epidemic or something of a disease.
I mean, you can kind of, if you're smart enough, if you're clever
Yeah.
enough, you could word national
Well,
security.
that's what
in a
happened here, I
way-
think, was that the first couple versions of the travel ban wouldn't have passed constitutional muster, but then,
We got
through
some clever
cause and effect,
attorneys.
we got it drafted in a way that it would. But that's interesting too, because like the ban was, and I think the majority opinion definitely talked about this, how the countries that were named in the ban, there was was it the secretary, that went through an analysis, one of the president's secretaries, like Secretary
Homeland
of State,
Security
the
went
Homeland
through.
Security secretary went through and said these countries, for these reasons, we think should be banned. So there was an analysis that
And then there was-
supported the claim of national security.
Right, and then there was like a period of time where the countries that we identified could kind of fix themselves and give us more information to take themselves off that list.
And a few of them were, like, where was it? Chad, Sudan, and Iraq were all originally on the list, and they were later removed.
Iraq's was interesting because I don't think they gave us any more information, but it was their efforts against ISIS and
That's what led to it.
Yeah. So there were different things. The majority basically said that the president had the broad authority, and then he went through the Homeland Security. They went through all of the additional steps that made it.
Yeah, and maybe it's not the court's place to step in these type of situations, which is what Kennedy was saying, that it's not necessarily the judicial branch's prerogative or even right to step in and just when the executive branch makes a proclamation like this. But it is interesting, we talked about this a little bit on the last travel ban video that we did after the oral arguments, how none of the banned countries have had any murders on U.S. soil. None. Zero. We posted the statistics. And because, you think of it, we don't want terrorists. That's what, like, people I hear, just on social media, that's what people are saying. We don't want terrorists in here, so that's why we have to have this ban. Well, those aren't the terrorists that are attacking America. The most murders on U.S. soil by terrorists come from the United Arab Emirates and Saudi Arabia, and those are two countries that are not banned. So, it kind of makes you question the national security interests a little bit when you see statistics like that. But, overall, like we said, you can read the majority opinion. It's very well reasoned. And, I don't think it's not that the court is saying that they agree with what the president did, but that it's not really their place to step in, and that the president has broad authority to enact these kind of regulations. And the courts are not there to rescind them when the president does that. So, we have anything else on this one?
No, I would say read this one.
Yeah, I mean, it's definitely a very interesting opinion, and we'd love to hear thoughts, feedback, comments. Let us know what you think, and subscribe, and we'll see you next time. Thank you for watching the Yoga Lawyer video.